Almost every week, a winnable employment case gets weaker for a reason that has nothing to do with what actually happened at work. It's old text messages. You probably think your group chat with a coworker is private, a place to vent, complain, joke around, maybe even plan your exit. It isn't. Once a dispute turns into a lawsuit, those texts become evidence, and the other side's attorneys know exactly how to use them. A single bad message can take a strong claim and gut it in front of a judge. There are real cases where someone had a genuinely strong claim on paper, a clear timeline, real damages, a manager who clearly broke the law. And then the employer's attorneys produce a screenshot from 18 months earlier, something typed in 30 seconds without thinking twice, and the entire value of the case drops by half. Not because the underlying facts changed, because a jury now has a reason to doubt them. So in this video, I'm walking you through 4 kinds of text you should never send a coworker if you care about protecting your job and your legal options. Save the worst one for last, because it can wipe out one of the most valuable claims an employee can bring. Quick disclaimer before we get into it. This video is for general education, not legal advice. Employment law varies by state and by your specific facts, so if you're dealing with a real situation, talk to a licensed attorney where you live. Let's get into it. Text mistake number 4. The "it's fine, I'm fine" reply. Picture this. A coworker or a supervisor sends you something off color. Maybe it's a comment about your body, your dating life, your medical situation, something that crosses a line. You're uncomfortable, but you also have to sit 2 desks away from this person tomorrow morning. So instead of saying anything, you just send back a laughing emoji, or haha, true, or a thumbs up to keep the peace. That small, harmless-looking reply can come back to haunt you. In harassment law, there's something called the unwelcome conduct requirement. If this behavior continues and you eventually bring a hostile work environment claim, you have to be able to show the conduct was actually unwelcome. The defense's whole strategy at that point is to dig through your text and hand the judge a folder of your own replies. Laughing emojis, thumbs ups, no objection ever. Their argument becomes simple. This employee didn't find it offensive. They found it funny, and they never asked for it to stop. Juries find that argument more believable than you'd think, and it can sink an otherwise solid case. The safer move, if a message crosses a line, is to respond plainly that the comment isn't okay. Or better yet, don't respond with anything that could be read as approval. Silence is far safer than a LOL. This trap isn't limited to obvious jokes either. I've seen it happen with comments about someone's pregnancy, their religion, their accent, even their disability. The pattern is always the same. The targeted employee tries to keep things smooth by playing along in the moment, and months later, that exact effort to be a good sport gets weaponized against them. If you genuinely don't mind a comment, and it really is just friendly banter between people who both find it funny, that's a different situation entirely. The danger is specifically when you're uncomfortable, but smile through it anyway in writing. Because writing doesn't capture tone, hesitation, or how your stomach actually felt in that moment. It only captures the words you chose. Text mistake number 3. The "already looking elsewhere" message. This is when you tell a coworker you've started applying to other jobs. The obvious risk is that word gets back to your manager and you suddenly become disposable. But there's a deeper legal problem hiding here, and it involves a claim called constructive discharge. Constructive discharge applies when you weren't technically fired, but conditions at work became so bad that staying was no longer reasonable, so you resigned. It lets you pursue a wrongful termination claim even though you're the one who walked away. The catch is that you have to prove the resignation was forced on you by intolerable conditions, not something you'd already planned to do anyway. If your employer's attorneys find a text from 2 months before you quit where you said something like, "Honestly thinking about looking around, the pay here isn't cutting it," your claim is in serious trouble. Now the company can argue you were leaving regardless, and the resignation had nothing to do with how they treated you. There's a second trap buried in the same category. If you mention to a coworker that you got an offer and turned it down, or that you took a few months off from job hunting, the employer can point to that to argue you didn't make a real effort to find new work after leaving. That directly reduces the back pay and lost wages a court might award you under what's called the duty to mitigate damages. Bottom line, your job search is nobody's business until you've signed something. Keep it off text entirely. One more wrinkle worth knowing. Even texts that have nothing to do with money can hurt this same claim. If you tell a coworker you're kind of excited about a new opportunity, or that you've already given notice in your head, even though you haven't said anything to your manager yet, that tone alone can be used to argue your departure was planned and welcomed rather than forced. Attorneys defending these claims aren't just looking for a smoking gun. They're building a narrative out of dozens of small, ordinary-sounding messages, and each one you send is a brick they can use. Text mistake number 2, the venting session. You had a brutal day. Your manager micromanaged every decision you made or made a call that cost the team real time, and you're furious. So you fire off a message to a coworker. "My manager is such a clown. I can't deal with him anymore." Totally human reaction. Totally risky in writing. Here's the legal mechanism at play, and it's called burden shifting, sometimes referred to in court as the pretext framework. If you sue for something like discrimination or retaliation, the employer doesn't have to prove they did nothing wrong from the start. They just have to offer some legitimate, non-discriminatory explanation for what happened to you. Often that explanation is invented after the fact. Poor attitude, difficulty with management, not a team player. Your job, through your lawyer, is to show that explanation is a cover story, what the law calls pretext. Now imagine the employer's attorneys produce a screenshot of you calling your boss a clown, or worse. Suddenly, their made-up excuse about attitude problems has real supporting evidence, straight from you. You've handed them exactly what they needed to make their story stick. If you need to vent, do it out loud to someone you trust, not in a format that can be subpoenaed. It's worth saying that venting itself isn't the problem. Everyone needs to let off steam about a bad manager or a frustrating decision, and bottling that up isn't healthy either. The issue is purely the medium. A phone call disappears the moment you hang up. A text sits on a server somewhere, sometimes for years, waiting to be pulled into a discovery request you never saw coming. If your venting habit lives in a group chat, consider moving it to an actual conversation instead. Your case, and honestly, your peace of mind, will both be better for it. And the text mistake you absolutely cannot afford to make. Number 1, the favor that breaks a rule. This is the message where you ask a coworker to bend a policy for you just once because you're friends and it's no big deal. The classic version is something like, "Running behind, can you punch me in?" Or, forgot to log the inspection. Can you just initial it for me real quick? It feels like nothing between two people who trust each other. Legally, you just created a written record of a fireable offense, and that triggers something called the After Acquired Evidence Rule. Here's how it plays out. Say your employer fires you for a reason that's actually illegal. Retaliation, discrimination, whatever it may be. You hire an attorney, and on paper, your case looks strong. But during discovery, the company's lawyers obtain your coworker's phone and find that message where you ask them to clock you in or fudge a log. Even though that's not why you were actually fired, the company can now argue that if they'd known about it at the time, they would have fired you for that instead. Courts allow this defense, and it can drastically cut down what you're able to recover. It can eliminate back pay and front pay almost entirely because the argument becomes, this person would have been let go regardless of what we did wrong. So the rule is simple. Never put a policy violation in writing, no matter how small it feels or how much you trust the person you're texting. What makes this category so dangerous is that it almost never feels like a big deal when it happens. Nobody texts a coworker thinking, this could end my lawsuit 2 years from now. It feels like an ordinary favor between two people who have each other's backs. But the After Acquired Evidence Rule doesn't care about intent or how minor the violation seems. Courts have applied it to things as small as inflating a timesheet by a few minutes or skipping a required checklist item. The size of the violation matters less than the simple fact that it exists in writing with your name attached to it. Now, before you go, I want to deal with the thought a lot of people have listening to this. But this is my friend. They'd never hand these texts over. It's not really about trust. It's about how litigation works. Once a lawsuit is filed, both sides go through a phase called discovery, where attorneys can legally compel the production of relevant messages, emails, and records. It doesn't matter how close you are with your coworker or how much they want to protect you. If a court orders those texts produced, your friend's hands are tied. They have to hand them over. Every joke, every vent session, every favor you asked for, all of it becomes available for opposing counsel to read line by line. So here's a simple habit to build. Before you send anything to a coworker about work, picture it blown up on a screen in front of a judge. If that thought makes you wince even a little, don't send it. It's also worth remembering that this rule doesn't only protect you in an active lawsuit. Plenty of companies pull text and email history during internal investigations too, long before any attorney ever gets involved. A workplace complaint, an HR review, even a routine audit can surface old messages you forgot you ever sent. The same caution that protects you in litigation protects you in those quieter, everyday situations as well. To recap, the 4 messages to avoid are the laughing along reply to something inappropriate, the casual mention that you're job hunting, the venting text about your boss, and the request to bend a rule on your behalf. Each one feels small in the moment. Each one can quietly dismantle a case you didn't even know you'd need yet. If this kind of breakdown is useful to you, the best thing you can do is subscribe and turn on notifications, because I cover real employment law issues like this every week. The kind of thing nobody tells you until it's already too late. Drop a comment if there's a workplace text or email situation you want me to break down next. I read all of them, and a lot of future videos come straight from what you bring up. One last thing before you go. None of this means you can't be friendly with your coworkers or that every message has to read like a legal filing. Most text will never matter to anyone. The point is simply to know which categories carry real risk so you can avoid them on purpose instead of finding out the hard way during a deposition. That's it for this one. Protect your paycheck, protect your case, and think twice before you hit send. See you in the next video.